Okay, great. Well, it looks like we've reached a critical mass and we're feeling pretty timely here today. So thank you for everyone that's joining or has joined. This is a webinar, so we won't be able to see your faces, but you should be able to see us. We are recording this, so you will be able to view after the fact, and anyone that isn't here will be able to join as well, or view as well. I know everyone's been waiting for this for a while, so we're excited to get everyone together for this. I think this will be a really good training to kind of paint out your roles and show you how you can how we can empower you and how you can be a great voice for your community that you represent on the neighborhood advisory board. We're trying to keep it an hour tonight, so if you do have any questions, we do ask that you put them in the chat. And if we can't get to your question, please email nabs@reno.gov. Tonight you'll be hearing from John Shipman. He's our assistant city attorney, and he'll be going over open meeting law and some basics for facilitating a neighborhood advisory board meeting. And then we have Angela Foos, who will be talking about, she's our planning manager, and she will be talking about cities development services department and the general process for development projects. And then we will have a Q&A after each presentation, but again, we are trying to cap it out at an hour as we will have folks viewing this afterwards. And one last time, I'm just gonna say, please send any follow-up questions you have to nabs@reno.gov if we can't get to that. So without further ado, I will hand it over to John Shipman.
Thanks, Nick. Yeah, thanks everybody for being here tonight. It's my pleasure. I'm John Shipman. I'm with the Reno City Attorney's Office. I'm the Assistant Deputy City Attorney to Carl Hall, the City Attorney. I'm going to go over the Nevada open meeting law, kind of the nuts and bolts, give you ideally the information that you need to make the most of your meetings. Just as a couple preparatory comments, I think one thing I would recommend people to do is, if you're curious about how to run a good meeting, I can't recommend enough maybe watching the Planning Commission. The Planning Commission is very good. Angela will attest to the fact that they are a very good body, and they know their motions and how to abide by the open meeting law. So I'd recommend you doing that, and that's a good learn by watching is a good example. So I'm just going to put up the presentation now, and hopefully this will work. Okay, does everybody see the presentation? Is that okay? Good. That's actually the first time that's ever worked for me, so I'm going to take that as a win. So again, tonight we're talking about the open meeting law, and here's an overview of what we're going to be chatting about. We're going to be chatting about first, where does it come from? NRS Chapter 241. We're going to talk about the concept of a meeting. That has a couple of different subcomponents. Namely the fact that meetings must be publicly noticed, and then meetings must be openly conducted. Then we're going to talk about everybody's favorite, what happens if the open meeting law is violated? What does that look like? What does that mean? And then we're going to have some discussion or present some information on things like email, text, social media, and electronic polling. Those also are important open meeting law concepts, becoming more and more important as the days go by. And then we'll talk about the motion guide. And again, this gets back to, I again recommend you watch either the City Council or the Planning Commission. You can probably learn a lot just by watching those two things. And then we'll open it up for questions on the chat, time permitting. And again, per Nick, if you do have questions, you can reach me through that Nabs email address. I'll be happy to get back to you. So with that, that's kind of our agenda. I'm going to try to go through this pretty quick. So, and again, as a kind of an opening comment, there is the Attorney General's office publishes a book on the open meeting law. And I would encourage you to get that book. It's online, it's free, you can download it. I'm sure we could probably provide you with copies or a link to it if you want it. It's a rather large book. A lot of it, I don't think you need to really concern yourself with, because I think you have great staff. They're going to make sure that you stay in your lane, and everything, from agendas to meetings being conducted are done according to Hoyle. So There is a book out there. If you do have questions, that's another place you can look. Again, I'm always here. Our office is always here. But I'm going to try to keep it to the stuff that you really need to know to survive. So NRS Chapter 241, this is where the legislature enacted the open meeting law. The open meeting law is essentially, it mirrors many of the open meeting laws across the United States. Pretty much every jurisdiction, every state has got some analog or some version of the open meeting law. What is the purpose of the open meeting law? As the legislature said, in enacting this chapter, the legislature finds and declares that all public bodies exist to aid in the conduct of the people's business. And here's the important point. It is the intent of the law that their actions be taken openly and that the deliberations be conducted openly. So those are a couple components. We're going to look at that, but that really in a nutshell is what the open meeting law is about. It's about what are you doing and what are you talking about? And I want to know and I want to be a part of that. So what is a meeting? This is a core concept to understand, and it will be very important for your purposes going forward. Meetings of public bodies, they have two requirements. They must be publicly noticed and they must be openly conducted in accordance with the open meeting law. So what is a meeting? That begs the question. Well, a meeting means a gathering of members of a public body at which a quorum is present. That's the first concept, to deliberate toward a decision or to take action on any matter over which the public body has supervision, control, jurisdiction, or advisory power. I will tell you that as a NAB, you are a public body. So this applies to you. And so from the standpoint of what is a meeting, we know that it has two components to it, a quorum and a deliberation or an action component. What is a quorum? Well, the law defines what a quorum is. And a quorum means a simple majority of the membership of a public body. So for instance, in the case of a NAB, if there are 10 members on a NAB, then a quorum of a 10-member NAB would be 6, right? Because that's a simple majority of the 10. 5 doesn't get you there, 6 does. If it was 7, the quorum would be 4. If it was, pick a number, and that's how you determine what the quorum for that would be. Then there's the notion of deliberation. And what is deliberation? And this is very important. It means to collectively as a body, examine, weigh, and reflect upon the reasons for or against an action that the body may take. And you can find that definition in NRS 241.015. So there we have it. We have a meeting is where we have a quorum and we have deliberation to take action. In my mind, I think of this kind of as the calculus of the open meeting law for math nerds out there. We have, and here's how I think of it. We know that meetings of public bodies must be properly noticed and openly conducted in accordance with the open meeting law. So if you do not have a quorum and you do not have deliberation or action, you certainly do not have a meeting, right? That's the first scenario. The second scenario is where you don't have a quorum, but maybe you have something less than a quorum. Let's say your body is 11 individuals. There's 11 people appointed to it. And 2 or 3 of them are chatting about maybe a matter that's in front of that board or would come in front of that board. So arguably you have deliberation, but the question is, do those 2 or 3 individuals talking about that matter, is this something that needs to be noticed and conducted in accordance with the open meeting law? And the answer there is, in that case, in that very limited scenario, the answer is no, because you do not have a quorum. So if you do not have a quorum, but you have deliberation, 1 or 2 members meeting and talking, it does not invoke the open meeting law. The flip side of that, let's say you have 11 people together in a room. Maybe they're there for a birthday. Maybe they're there because it's a parade. Maybe they're there, it's for whatever reason, but they're there. They're in the same, occupying the same physical space, but are they talking about anything or learning anything or taking action on anything that would come before the body? And if the answer is no, you do not have deliberation. So does the open meeting law apply? No, it doesn't, because you don't have the quorum and the deliberation components required for a meeting. And then the one we're all familiar with, and this one gets a little tricky and you got to just be aware of it, is so you have a quorum, you have maybe 5 members, 6 members on an 11-member board. And they're talking about something that is potentially in front of the board or should be in front of the board or they have jurisdiction over. Do you have a meeting? And the answer is yes. Okay, so there's a caveat here, and we'll talk about that real quick, but that's what you need to be thinking of is how many people am I talking to about this that are on the committee? Is that a quorum? And is this a matter that's in front of the body? And if the answer is that, it says yes, then that should be telling you that, oops, this is something that needs to be put on an agenda, needs to be noticed and conducted in accordance with the open meeting law. Now, there's a couple sort of what I'd call categorical exemptions to this. Social gatherings, like, we talked about a birthday party, maybe it's a civic function for the city, a gathering of artists, which they're doing currently right now downstairs. So the law says, look, if you're in the same room for a social gathering, it's not going to apply. Trainings, like we're doing here today, this is not subject to the open meeting law. Similarly, like attorney-client communications, if I, for instance, had to talk to the body about maybe a matter that was in front of the board where there was pending litigation or somebody was suing the city, those communications would not be subject to the open meeting law. But I would just point out, just because you're at a social gathering, or just because you're at a training, or just because you're in an attorney-client meeting, that doesn't give you free right to discuss matters that are properly or should properly be put on an agenda and openly debated and discussed in public. What it says is the law is going to presume that you are not talking about city business in those meetings. But if there is evidence that you are in fact doing that, there is the ability for the Attorney General or for a party that feels like they've been wronged to bring a lawsuit and provide evidence that that in fact is the case. So again, takeaway is if it's a social gathering, a training, or an attorney-client meeting, you're okay, but still don't be talking business. It's the best practice. So we talked about meetings. They have the 2 requirements. The first one is they must be properly noticed. And for that to happen, the meeting agenda must be published physically and online no later than 9 a.m. on the 3rd working day. And that's another key concept before the meeting. So, so if you're going to have a meeting on a Wednesday, for instance, when would you normally have to post that agenda? That agenda will have to be posted by Friday morning at 9 a.m. So you get Friday, the full working day, Monday, the full working day, and Tuesday, the full working day. You don't count the day of the meeting for that. And it has to be prior to 9 a.m. to get the benefit of that day as a working day, counting towards that deadline. You got to be careful there. It's probably not going to be a problem for most bodies because, sometimes you'll have things like Memorial Day or, 4th of July and it falls on a Monday and you can run into problems. You just got to be mindful of it, but staff should take care of that. But again, there has to be those 3 working days of published notice to the community that you're going to be talking about a particular item. What's on the agenda? Well, the agenda must include at a minimum the time, place, and location of the meeting. We have the ability to do virtual meetings right now. I imagine we're going to probably be doing more physical meetings very soon. So you have to notice that on the agenda. Again, this will be taken care of by staff primarily. Now, the important one here for your purposes is that there needs to be a clear and complete statement of the topics and the actions scheduled to be considered by the public body during the meeting. So you'll hear this talked about a lot of times with people saying, look, don't go off the agenda. That's not on the agenda. We're not noticed or styled to hear that information. It's a very common sort of thing where, you have an item for consideration and for taking action on it, and it brings up another item that's not on the agenda. You've got to be careful there, and this is where potentially staff will help out, be it the city attorney's office, be it staff, be it other people, that if the public isn't put on notice that you're going to be talking about a matter, you should refrain from talking about it. And the proper procedure there is that you come back at a later date with notice that you're going to be talking about something that wasn't on the agenda prior. So, and again, to be clear and complete, it needs to tell you what the topic is and what the potential action is. So keep that in mind when these titles are put on the agenda. State, again, my preference would be stay in your lane. We'll talk about potential violations later. And then in addition, the agenda must include a minimum of 2 public comment periods. I think that's just standard how we're doing it now, at the beginning and at the end, and then potentially for every item, public comment can be taken. And then finally, supporting material. That's material provided to the public body by staff or a member of the public body. So, you know, if you're on the board and you're providing other materials to your fellow board members, that must be provided to the general public as well. And I would tell you, if you are circulating or you want to circulate information to your other members, work through staff on that. I wouldn't just give it to people and not give it to other people, or take it onto yourself to give it to everybody, but not give it to the public. If you think it's important for the purposes of deliberation, something that's moving the needle for your discussion, then you need to give that information to the staff, and staff will make sure that that gets distributed, provided it's the type of thing that falls within the clear and complete statement of the topic and the actions. So that's what it takes for a meeting to be properly noticed. That's the first point. Secondly, the meetings must be openly conducted. And what does that mean? Well, for public comment, you know, we talked about it. You have it at the beginning and the end of the meeting. The rules for public comment are generally on the agenda. Normally it's 3 minutes. In general, the presiding officer cannot limit public comment based upon viewpoint. You can't tell a person, I don't like your opinion, you know, stop talking. You know, the one exception to that is if it's a decorum issue. I mean, if it's, you know, and that's something staff can help with. If somebody is, you know, being really profane, doing things to really interrupt the meeting, then potentially you can cut them off. Overall, I would say that you probably just want to hear out the public comment and then move on. The important thing about public comment, and the public gets frustrated with this, is no action may be taken upon public comment until a clear and complete statement of the topic and the action is included on a properly noticed agenda for future meetings. So sometimes somebody wants to come and they have a complaint and they talk about it in public comment, and it's like, thank you, you've heard your complaint, but then they want to talk about it. You have to be careful there, because you can't take action, so I just want to put you on notice and be aware of that. Again, discussions, deliberations, and actions of the public body must be public, recorded, and confined to the scope of the public agenda. So can you have a secret ballot? I've gotten that question over the years. No, you can't. You know, you can't say, you know, everybody pass me a piece of paper, how you want to vote. Those votes have to be, and the discussions leading up to those votes have to be public. The meeting itself has to be recorded, either on video or tape recorded, or whatever the media they use nowadays or are going to use. And then it has to be confined to the scope of the published agenda, and we talked about that. If it's something that's not clearly notified in the public that you're going to talk about it, refrain from talking about it. Here's another big one. Do not discuss the character, alleged misconduct, professional competence, or physical or mental health of any person. That's just a general no. There's really no reason, especially as a NAB, for that to take place. You know, I don't expect it to take place, but sometimes, you know, people will start, you know, for lack of a better term, name calling or making accusations or allegations about other people. Don't take that bait. There's actually specific provisions in the open meeting law that protect people from public bodies discussing these types of matters about them. And there's a whole, you know, a procedure that you have to go through to protect people, to make sure that you're doing it right, or if you wanted to close a meeting. So just as a general point, don't discuss character, alleged misconduct, professional competence, or physical mental health of any person. Please, I don't imagine that you need to do that, and don't get baited into doing that. And then finally, for a meeting to be openly conducted, the action requires concurrence of the majority of members present. So if, you know, if a NAB, for instance, wants to make a recommendation, there's 11 members on the NAB. There are 6 members that show up for a meeting. 6 members equals a quorum. So how many people do you need to vote for a motion to make a recommendation to council? Of those 6 sitting members, you need 4, right? So you have to have a majority of the members present. So that's important. If you had 10 members there, how many votes would you need? You would need 6. If you have any questions about that, we can come back. But you just have to be aware of how many members are present and then what the number of votes are that are needed to pass a particular motion. So then that leads up to the next question. I see there's stuff in chat, so I'm just going to try to roll through this and then I'll get back to the chat questions. But it leads into the next question, violating the open meeting law. What is it and what happens? Well, if it happens, what the law says is that any action of a public body taken that violates NRS chapter 241 is void. So if a body makes a recommendation, but the agenda wasn't noticed correctly, then that recommendation is void as a matter of law. Or if it was taken in secret, again, that would be a matter that would be void. So what is kind of the remedy? There's actually civil and criminal penalties potentially will attach for violating the open meeting law. Generally, it's pretty infrequent that this happens. I mean, I've never in my 20 years career have seen a criminal violation be prosecuted for the open meeting law. I think people understand that, people are serving on boards and public bodies, and, the idea is not to make, subject them to criminal liability. So that's very rare. And like I said, I've never seen it in my career. I have seen civil penalties, but, that's, again, those are very, very few and far between situations. So, but the civil piece is each member of a public body who attends a meeting of the public body where the action is taken in violation of the open meeting law and who participates in such action, and here's the key component, with knowledge of the violation. So if you're essentially talking about an item that's not on the agenda and it's not on the agenda, and somebody, maybe a city attorney, maybe a staff member said, hey, or maybe the chairman of the committee said, look, that's not on our agenda. We need to not discuss it, but you continue to discuss it and other people discuss it. That would be a violation of clear and complete. That potentially would be the type of thing that the Attorney General's office or a party seeking criminal or civil penalties, you could potentially be dinged and fined in an amount not to exceed $500. Again, I'm not saying that this is common or this is something that happens or I expect to happen. It's just something to be aware of. And the key is the knowledge. So if somebody's saying, hey, I think this is outside the bounds of our discussion, your ears need to perk up. And because if you cross that line, there may be consequences. And again, the knowledge component is important on the criminal side. And I haven't seen that, so I'm not expecting that. Here's a big one. I mean, this is really, kind of developing email, text, social media, and electronic polling. Now that everybody has a phone and everybody's on their phone and everybody's looking at their phone and everybody's texting on their phone or TikToking or whatever it is. What the law says is that electronic communications cannot be used to circumvent the spirit or letter of the open meeting law in order to discuss or act upon a matter of which a public body has supervision, control, jurisdiction, or advisory powers. So what would this look like? This would look like maybe a couple members are texting during a meeting between themselves saying, hey, I don't really like this, or maybe this needs to change or something. But those texts are just a private communication during a meeting. That is very much a violation of the open meeting law potentially. So because now the public is not seeing that actual deliberation. The public's not seeing the action that's being taken. So you got to be very careful with that. I mean, that goes with social media too. That's a developing area. You talk about Facebook, and I'm not a social media person, but where you have a Facebook feed, and then pretty soon you have a majority or a quorum of a NAB membership weighing in on an issue. That starts looking like a quorum, and they're deliberating. And in the, and then if it's a quorum and it's a deliberation, that requires a meeting to be held to discuss that. So you're potentially in violation if you're commenting on something that should be in front of, that everybody's commenting on. So you got to be very careful with that. Same thing with emails. You send, it's kind of like, what is it, telephone? You send an email to one member, that email gets forwarded to the next member. Pretty soon it's forwarded to more than a quorum of the membership. And it's talking about matters that are rightly in front of the NAB. That is going to be a violation because that triggers a meeting. You have a quorum, and the problem with defending that, as you probably know, is that it's very difficult for me, a city attorney, to be saying, there wasn't a violating meeting here, because it's all in email or it's all in text, and you can actually follow the text thread or the email thread. So be very careful with that. Once you start talking to more than maybe one person, or you start talking about what other people think, or you got to start thinking to yourself, am I getting into a position where I'm potentially violating the open meeting law? And if you have a question, again, reach out to staff, reach out to the city attorney's office. We're happy to talk you through it. But remember, and this is it, the calculus of the open meeting law: quorum plus deliberation equals a meeting. This slide, this slide comes from the city council meeting, the city council rules. It'll make a lot more sense when you watch a meeting or two, like of the planning commission, as I said. These are motions and examples of if you want to do certain things in a meeting. So if normally the way it works, if you'll have an item, the item will be called, there'll be a staff presentation, or there'll be a public comment taken. Once the presentation is done and the public comment is done, maybe there's other presentations that are done. Then a board member will generally make a motion, and that motion could be anything it should be what's in the title of the item. So if the motion is to approve a project, the motion is to make a recommendation to the city council, and you'll see that, a member will say, I motion that, we recommend to the city council X, Y, and Z. Then normally the way it works under the Roberts rules is there'll be a seconding of that motion. After there's a seconding of that motion, there's a discussion about the motion. And then ultimately that's followed by a vote on that motion. And what you see in the Exhibit A motion guide, there's a bunch of other things that maybe you want to do at a certain point, so maybe the discussion keeps going around and around and around and it's not getting anywhere. Then you can motion to close the debate. I move to close debate. And then the body votes on that. And then if it succeeds, then debate's closed and you're to your main motion. If not, then discussion will continue. A roll call vote, that's another one. If ask, especially on video conferencing, when you want to make sure everybody knows who voted for what, somebody may call a roll call vote. A motion to reconsider, that's where, hey, look, maybe I voted wrong on something in the past, and I want to bring it back and talk about it again. You can bring a motion to reconsider. So anyway, if you have any questions about any of these in particular, city attorney's office or staff can answer questions about it. And so with that, I'm going to conclude the presentation, and that's my email address and my direct line, shipmanj@reno.gov, 775-334-2057. Feel free to reach out to me. And then let me close this up. And then let's go to, do we have any questions? Okay, so, and I apologize. Let's see. This is from Carla. Maybe he will cover this. I was pleased, but also dismayed that an old friend was able to find my personal contact information because of my role on the NAB and Parks Commission. While I understand that the names of the members should be public record, perhaps more available to the press via the Freedom of Information request, I don't really like the idea of John Q. Public being able to find and contact me about any agenda. Is that revelation required? So, one of the trade-offs, and this is why, my heart goes out to people that volunteer for boards like the NAB. I mean, God bless you, because I mean, it's the public's business. And as part of that, what we see is that there's a certain amount of, you're in the public forum at that point in time. And privacy is a little different in a public forum, especially when we're talking about public policy and whatnot. In terms of personal contact information, I think, I mean, I just as an aside, I think we're taking another look at that at the city clerk's office and trying to figure out exactly where we can draw the line so that, you know, we're not collecting an overabundance of information. I mean, I think there's certainly people should be able to contact you, and for certain commissions, we do provide email addresses so that, you know, I think Planning Commission being one of them, so that if people want to officially talk to you about a matter that's in front of the board, they can contact you through a city channel. We'd like that as well, because then we can, then when there's a public request for public records request for that communication, we have a record of it. But I think we are mindful of the fact that maybe we don't need to request 3 telephone numbers, 4 email addresses, you know, and your mother's maiden name. So I think we're looking at what we can do to try to pare that information down. So, but anything that you say on the record, anything that is a public record, if you're discussing a city business, and I think you're going to get some training on public records at some point, you might as well assume that anything that is city business that touches you or your phone or whatever is going to be deemed a public record, and it may have to be turned over at some point in time if somebody requests a copy of it. So just be very mindful of that. But I do understand and appreciate the concern, and like I said, I think we're trying to maybe address some of that.
John, I'm going to help maybe move through these a little quickly, just so we can make sure we have time for Angela's presentation as well. We have a question from Gary Cecil asking about if a NAB member gets off course in a NAB meeting, who is the person who would identify that and I guess make that call?
Yeah, so normally that's the role, the general role of the presiding officer. It's also the role if you have legal counsel there and they see that happening, staff. I would say it's incumbent upon anybody who's in that meeting, especially any member that's on the board. If you feel like uncomfortable that maybe this is getting off topic, notify the presiding officer. If the presiding officer isn't picking up on it right away, at least ask the question, because when you ask the question, then we can make that determination pretty quickly. And if it is an area where we're not totally going off the rails, and we can get it back without a violation. So that's a great question. I think it's everybody's role. Okay.
I'm going to skip over Jared Souther's question at the moment, because it's more pertaining to planning or to projects that you guys submit forms for, which Angela will be covering those more. So we'll circle back to that one after her presentation. Let's see it. So Gary Cecil had another question. As minutes are part of the public record, under what conditions is it appropriate for a NAB member to suggest changes to meeting minutes? And I know that we've talked about this in Nabs before. I'll just mention that the purpose of minutes is not to have a transcript of the meeting or to have necessarily quotes, but to be recording the motions that are taken and maybe key highlights of different points of discussion between the NAB members. But I'll let John speak more to that as well.
Yeah, that's a good question. The meetings are part of the public record. They're kind of the permanent public record. And you know, we can get out, look at the Attorney General's open meeting law manual. I think they talk about the minutes pretty in depth and in detail about what needs to be there. But it generally is just to let the public know what happened, what was discussed. I mean, they can be pretty brief. If you are at the meeting and you were participating in the discussions and you think that you were misquoted, or if there was a problem with what the meetings reflect, normally the meetings are approved at a subsequent meeting by the body, and you are totally within your rights to say, I think that, you know, I was misquoted, or this is not what I said, and you can make a motion to change the meetings, to change the minutes. And if the rest of the public body agrees with that, you know, upon review, then the meetings will be changed to reflect that motion. So yes, there is a mechanism for that.
Awesome. Thank you, John. That was thorough and really informative. And if people have additional questions that are going to be directed to some of the topics that John covered, you can still add them to the chat, and we'll be taking a record of those and putting out kind of a FAQ sheet to just clear up any questions that are relevant to the whole group, or if they're more specific, we could reach out to individually. And we're going to throw it over to Angela to cover some of the stuff with development projects and what's happening in her department. Thank you, John.
Hi, good evening. My name is Angela Foos. I am the Assistant Director for Development Services. And for those of you that don't know what Development Services covers, it's everything related to planning and zoning, engineering, and building. So it's basically anything related to development from the private sector perspective. So I'm going to go ahead and do a shared screen. Okay, so I have a quick presentation today. I'm going to focus on a couple key areas. Because we have only a short window today, I'm not going to go into a whole lot of zoning detail. Again, I'm going to give you just a broader overview of what zoning covers. And when we review applications, whether it's a building permit or a planning application, just to give you an idea of the things that we look at and the regulations that we follow as part of that review. I also want to talk to you about development process. There's been a lot of questions about how come that project that's being built didn't come before the NAB, or how come that project went to city council. So I'm going to give you just again, big picture, how we decide which development projects go before a NAB, which ones are triggered to go before a planning commission, and which ones are triggered to go before a city council. And then finally, I'm going to talk to you a little bit about the roles of NABs and what you are looking at and what your purview is when projects come before you. So big question is, what is zoning? Just from a definition perspective, zoning is really anything that's a municipal or local law or regulation, and that governs how property can be or cannot be used. An interesting tidbit of information is that every single jurisdiction has a different zoning. So while we have universal building codes and fire codes, those are national codes, we have very different zoning regulations based on jurisdiction. So we have different regulations in Sparks than we do in Reno, than we do in Washoe County, than we do in Fernley and Carson City. Each of our jurisdictions sets our own regulations. And what's in that document, that zoning document, is things like, what are my setbacks? What's my zoning designation? How many trees are required if I'm going to build an apartment project? All that level of detail is what's in a zoning document. So why is this important? High level, big picture, what we don't want to see is, for instance, a school being built near a nuclear power plant, right? That doesn't make sense. And all of us from a high level can say, of course, that doesn't make sense. Who would ever put an elementary school next to a nuclear power plant? Well, that's what the purpose of zoning is really to protect our citizens and to come up with a path forward so everyone knows what the development rules are. In terms of here at the city of Reno, we have a couple of guiding documents that we look at. From the highest level, we have the Truckee Meadows Regional Plan. This is a plan that looks at land use between Reno, Sparks, and Washoe County. So again, it's not specific standards to say what your setbacks are. It's bigger picture to say, okay, as a region, as a broader community, where do we want to see growth? Do we want to see growth on steep hillsides? Do we want to see growth in areas that have an open space designation? So it's very high level, and it's a document that was agreed upon by Reno, Sparks, and Washoe County elected officials. So again, that's very high level policy, master plan level. Below that is the Reimagine Reno master plan. This is a document that we spent several years getting community feedback on, and that's specific to the city of Reno. And it's policy level, so it does not set regulations or standards. It sets the big picture. How, as a city, how do we want to grow? Do we want to grow out, meaning more sprawling development? Or do we want to grow up, meaning more infill? And it's interesting from a big picture perspective. Most of us would agree that infill is a good thing. Right? We don't want to see just sprawling suburb after suburb. But when it comes down to actually infill in the community that we live in, we see the challenges. Because if you live in a community, a neighborhood, and you've seen that maybe there's a vacant site next to you and somebody wants to come in and put apartments or some kind of a mixed use development. Immediately you're thinking, whoa, 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 that's going to change the community character. That's going to add traffic to my roads. That's going to add nuisances like noise and lighting and people to my community, my neighborhood. So we really have this conflict of, as a region, we don't want to keep sprawling growth, but when it comes to actual infill and where we want it, how do we do that in a way that really protects those neighborhoods and make sure that they're not being impacted in such a negative way? And that's where the zoning code comes in. So our zoning code is about 650 pages. You can imagine trying to interpret and understand 650 pages of zoning regulations. It's very difficult. One thing about zoning is it's not black and white. There is a lot of gray. And that's why we have planners here at the city of Reno that have to interpret the code. So anytime a project comes in for review, whether it's a building permit or somebody that wants to split their lot in half, we refer to that zoning code and we say, okay, from a basic level, is that use allowed? And then how have they designed this site to meet those regulations? The big picture in terms of how development works. You guys see development happening everywhere, and you see the impacts of the roads and the sidewalks, and trees coming in, buildings being built. How do we kind of follow that transition from an idea to when it's actually built? So I put this little slide together just to give you a little bit more general concept of when we're looking at development, all the things that go into development. So first and foremost, we ask the question, does the zoning allow that use? We go to our zoning code. We have about 10 pages that's specific to every use you can think of, whether it's a nail salon or a waste management facility. It's every type of use you can think of. And then we have all of our different zoning categories. We probably have 20 different zoning categories. So we'd say, number one, what's the zoning of that property? And is that use allowed in that particular zoning district? Step one. If it is, you kind of go to the next step. Great. So you can put let's say a barber within that general commercial zoning district. Great. Well, let's say it's a vacant site. I'm going to build a building. So what are the things what we require? Well, we require that you follow certain setbacks, right? That's the difference between the space from your property line to your building. We want to make sure that that's consistent. We also look at how tall your building is. We have limitations on how tall you can go. We have limitations on how really big the footprint of the building can be. It's all dependent on which zoning category you're in. And then we have requirements of how many parking spaces is required and how many trees are required. And the interesting part is it's not, again, black and white. Depending on which zoning district you're in, we have more flexibility. If you're in the downtown area, for instance, that's an area where we are trying to encourage density and encourage infill. So you have a lot more flexibility of what uses are allowed. You can do bars, you can do restaurants, you can do apartments, you can do offices, you can do a number of uses by right, meaning there's no public hearing process. They are approved by right and go straight to a building permit. If you're in, say, a residential area where you have a residential zoning, a lot of uses you cannot do at all. You cannot do bars in most residential zoning districts. Even a lot of apartments you can't do because of that density isn't allowed in those residential zoning districts. So all of that kind of goes into the design when a project comes in. And then the next step would be actually building the building. And that's where we refer to our building codes. And again, those are all international building standards. So that's not really specific to Reno. Reno doesn't write those regulations. We follow just the national standards for how buildings are safely built. And in terms of fire, how we can make sure that they are built according to fire codes and regulations. There's not a whole lot of flexibility. There's not a whole lot of gray area in those standards compared to zoning, where it's, again, much more of a gray area. And then finally, you get to the point where your building's built, you've got your business in, but now you have to get a business license. So we have a whole nother set of regulations on what types of businesses require different licenses and approvals through either city council or just by right through our business license department. So there's a whole lot that goes into development that the average person doesn't know about, or it doesn't really come before the Nabs because it's a different level of review. What types of developments are out there? So we know that what the Nabs see are things like zone changes, master plan amendments, subdivision maps, we call them tentative maps, and conditional use permits. So I put together just all different types of applications. Many of these don't come before the Nabs. Only the ones that trigger any kind of public hearing would come before the Nabs. And again, what you're looking at is from a zoning perspective, doesn't make sense. We get a lot of I think frustration from neighbors when a development has come in and people will say, well, how can you, City of Reno, allow that use next to me? It's going to completely change the character of my neighborhood. And we go back to that zoning code, and the zoning code was adopted by City Council and specifies these are the uses that are allowed by right. So while maybe you as a neighbor don't like it because it's next door to you, this is what was agreed upon by the Reno City Council at some point along the way. So what we look at then is when a project comes in is, are they meeting all of the other requirements? You know, have they provided the correct number of trees in the right location on that site? Setbacks is a big one, and height. You see a lot of things where you have a single family home and next door is a 3-story apartment. You know, does that make sense? And the great thing about the zoning code is we have all these separate little requirements where you're adjacent to residential zoning, for instance, to 1-story house. We have additional setback requirements. So by right, let's say your setback is 5 feet. We have all these different separate regulations that say, well, except in these zoning categories, we want to make sure that we buffer adequately. And so that those single family homes are protected as much as we can to allow multifamily in that development, for instance, but make sure that you don't have a 3-story building 5 feet away from your 1-story single family home. So all that's taken into consideration. And again, when you guys see the projects, you know, those have first come in, staff hasn't sat down and reviewed every detail of those projects yet. So the applicant will come and present to the NAB. And usually the staff will be there to answer questions, but we haven't done a thorough analysis yet. We haven't determined what meets code or what doesn't, or kind of where that gray area of flexibility is. So those are all the things that you should be kind of paying attention to and looking at. And you don't have to know the zoning code, right? That's not your job as NAB members. That's the job as the city planning and engineering staff to know those regulations. Your job as NAB members is to say, well, does it make sense? Is it compatible with this neighborhood? Going back to, again, if the zoning code says that use is allowed in that neighborhood, there's not a whole lot of flexibility to deny a project that we said wasn't allowed use. But the things that as NAB members you can look at is how to make it a better project. Let's talk a little bit about, again, you know, what types of projects require a public hearing and what are all those different types of public hearings. So number one is the Planning Commission, and they vote on projects as opposed to the NABs, which provide input. The planning commissioners are appointed by our city council members, and they meet generally twice a month. And so any project that requires a planning commission approval will come before them. By that time, the project has come before the NAB and input has been taken in. The staff planners and engineers and fire department and the building department have all kind of weighed in as a preliminary review and provided a written comments. And we do that in form of a staff report and conditions of approval. So those conditions of approval are basically additional requirements that we've put on the project. And a lot of the things we look at again is compatibility with the neighborhood. You know, if it's something that's allowed by right per the zoning code, we can't deny it just because people don't like it. It was already agreed to by city council when they adopted that zoning code that use is an allowed use in that zoning district. But are there things that we can do to make sure that the neighbors are protected? Again, the big ones that we look at is anything that we would call a nuisance, you know, headlights. If you have an apartment project, it's a great example again, where you have a lot of parking, you've got headlights shining onto the neighboring property. Have they designed the site to kind of mitigate those impacts? Typically, we require fencing, we require additional buffering, maybe through landscaping or some kind of a wall. So those are the kinds of things that the Planning Commission looks at based on the input and the recommendations from the planning staff. So level one, again, for a public hearing is that Planning Commission. Now, a lot of projects, once they are approved by the Planning Commission, are done and they can go straight to a building permit. There's other types of projects such as a zone change or a master plan amendment that also require an additional review by the city council. So not all projects go to city council, just a certain number of them, and specifically annexations. Again, if you're taking something from unincorporated Washoe County, annexing it into the city, so it becomes city jurisdiction, that goes straight to a city council. All zone change and master plans require both planning commission and city council approval. and some of those bigger projects, such as a planned unit development. More recently, you guys have seen the Daybreak development. That was probably the last really big development that went through the public hearing process. Those types of projects also require NAB comment, planning commission approval, and city council approval. Some projects are even required to go to another level, which is the regional planning, either the governing board or the regional planning commission. So that is yet another level of review to look at high level policy decisions on land use. Now, we also do a ton of projects that the planning and engineering department reviews before it goes to a building permit. And we call those more of our 30-day administrative review. So an application comes in, it's not a building permit yet, it's still just a preliminary review. We review it, we look at big picture things. Again, have we addressed concerns about parking and that those noise issues and those lighting issues? Have we addressed all of that as part of this application? And then we write a staff report with conditions of approval. That's a 30-day review process, and those do not go to the NAB for review. They're a very quick turnaround. We do send out public notice. So anytime there's a project that triggers one of those administrative review processes, such as a site plan review, that would come in for us to review. We have 30 days. And we send out those little yellow postcards that notifies the neighbors, everyone within 750 feet, about that project. And so they have an opportunity to go online and review it and provide comment to the staff. And that's super useful for our staff. Again, they're looking for feedback from the neighbors. What are the big issues, right? Especially for the neighbors that live in a neighborhood, they know what the concerns are, often more so than a technical planner or engineer would know. So we really look to the NAB comments, we look to the neighborhood comments to see if there's things that we can do to help mitigate those impacts. And then after that, there's projects that go straight to building permit. We've seen a lot of those in what we call our mixed use areas. So most projects, most new development in downtown goes straight to a building permit. There's no public hearing. There's no 30-day review process. It's straight to a building permit where it's all just a technical review. There's no public hearing. There's no public, little yellow postcards being sent out. And you think, well, why do we do that? Why don't we require all development to go through some kind of public hearing? So just big picture, we process about 13,000 building permits a year. And if you can imagine every single building permit that came in, if we had to send out public postcards, it would be a machine. We would just be nonstop sending out public postcards for 13,000 building permits. We currently process, I think about last year, I think we were about 100 planning applications. So all those applications are the ones that I'm talking about that get publicly noticed. That's about 100 applications, which may not seem like a lot, but when you're processing 100 big applications that generally take about 3 months to get through the process just to get to a planning commission, it's a lot of work. It's very time intensive. It's very technical. So again, some projects by right go straight to a building permit. We also have from our zoning code certain types of development where we want to encourage density, where we want to encourage certain types of uses by right. So per our zoning code, our council has elected to allow those types of uses. Apartments in the mixed use area can go straight to building permit by right. And yes, they absolutely have impacts on surrounding development, surrounding neighborhoods. But we hope that our zoning code kind of has that trigger to say, well, these are the things that are really above and beyond what's okay to put in that neighborhood. So we kind of try and have that balance between what should trigger a public hearing versus are there rules and regulations we can put in place to ensure that development is done in a way that doesn't negatively impact the surrounding community and surrounding neighborhood. So again, that's big picture of why you see certain projects going to NAB before you and why you don't see everything coming before you. I know there was a question in the chat a while back about how come NABs don't vote on projects. The way our neighborhood advisory boards are set up, and that's specific to the city of Reno, is that you provide comments, you provide inputs, and those comments are captured in the staff reports. We make sure we include all of those written comments that goes to planning commission and that goes to city council. But our NABs are not voting boards, at least on development projects. They are just more of an advisory role. Our planning commission is the commission that votes on projects. And then of course, city council also votes on projects. So from that perspective, again, we definitely look to the NAB members to understand the community, to hear what the neighbors have to say when you're at these NAB meetings, and then provide input and written feedback so that we can make sure we capture those comments. Staff can take that into consideration, and then planning commission and city council can also take that consideration in determining which projects they approve and which conditions they add on these projects. So Amy and Nick, that is the end of my presentation, and I will open it up to questions.
Awesome. And we'll go, I see a few questions coming in the chat, Angela, if you want to work through those a little bit. And we'll go a few minutes over just to get some of these questions answered and wrap up by we'll say by 6:40 at the latest.
Okay, so let's, just gonna try and go up to the top of the chat. Let me know if I'm missing any of these. Let's see, what building code requirements are aimed at reducing fire potential, such as roofing materials? Also, are there requirements for defensible space? Yes, so we do have defensible space requirements. A lot of it's dependent on where your building is. If you're in downtown Reno, there are no defensible space requirements. We have building code and fire code requirements. And that determines which buildings are required to have sprinklers. It's based on what type of building you have. For instance, a single family home would not be required to have fire sprinklers, but an industrial building, a commercial building, a school, those types of buildings are required to have fire sprinklers. In terms of some of our outlying areas, depending on where you're at, we have maps that define how high your fire risk is, and then defensible space requirements kick in. And that's things like how far you can plant trees and vegetation from your building, what types of wood your fence is made of, and what types of even single family homes where they're triggered to have sprinklers. We do have a lot of areas. I think Bird Eye is probably a great example. There's not a whole lot of new residential development out there, but we're starting to see a lot more residential development. Most of those homes are required to have fire sprinklers just because they're in a high wildfire risk area. And then next question, why does a NAB not get at least an initial staff report presentation about a development case on the agenda? So again, what we're looking for when an application comes in is for the NABs to give us comments. We don't want to feed you our comments as staff. We're looking for input from a big picture perspective. So we ask that the applicants come and present their projects, and that's where the NAB members can ask questions. And then we try to incorporate your concerns. You know, if we have a staff report, that means we've vetted it. We've spent 2 to 3 months reviewing this. We've gone back and forth with the applicant, trying to address those neighborhood concerns to come up with that staff report. So that's the role of the Planning Commission, is to review the staff report and staff's recommendations, whereas the NABs is to provide your initial thoughts and feelings and input on a project. And then we had exactly that happen, a tall structure, let's see, incompatible with the neighborhood, built 5 feet from the property line, shattering our house. So do neighbors have any options in these situations? We certainly were not asked before it was approved. And how much was the community involved in crafting these rules? So again, depending on where the site is located and what the zoning district is, different rules apply. So not sure specifically where your development was. If you're in some of these core downtown infill areas, it's really sky's the limit. There's no limit on density. There's no limit on how tall a building can be. And that's specific to certain zoning districts like your downtown, midtown area. The further out we go, more of the suburban areas we go, the more restrictions we have. And so we have bigger setbacks depending on what your zoning is, depending on how big your parcel is. If it's a project that went straight to a building permit, there was no opportunity for the neighbors to weigh in. If it's something that triggered either a planning application or some kind of entitlement, then it would have gone through a public hearing process or a site plan review process where we send out the postcards and you can comment. But a lot of this is dependent on, again, a 650-page zoning code. So it's tough to have a one-stop shop to say it's appropriate here, but it's not appropriate here. So that's where the zoning code really is that gray area of how do we create a community where it makes sense to everybody when we know there's going to be these one-offs? Because even in downtown, we have single-family homes. And is it fair to have a 15-story high-rise next to a one-story single-family home? Probably not ideal. But again, the downtown areas are where we want to encourage the most infill and the most density types of uses. All right, so next question. How often does the city review the appropriateness of the zone's allowable uses? And how would a citizen group go about asking for change? So we actually adopted a new zoning code. It was a little over a year ago. And that was probably the first time in 15 years that we did a mass overhaul of our zoning code. And that there was about 18 months of public input as part of that process. Now we intended to do what we call a 6-month update. So you adopt the zoning code, you start working with it and seeing what works and what doesn't. And then you go back and you make small updates. It wasn't intended to be a major overhaul. So just due to staffing resources and just changes in staff, we have not had an opportunity to go back and update the zoning code. So it's been over a year, and that's on our list of things to do. So as staff, we are writing down everything that we're like, this doesn't make sense, this isn't consistent, this has got to change. We're up to 210 things on our list to change in the zoning code. We have a lot of changes. And again, until you really get into it and start working with it, you don't even realize the inconsistencies or the areas are like that didn't make sense. I don't know why we did that. So I think if there are specific things that you as NAB members or just as neighbors, if you're like, this doesn't make sense, I think this should go back to have another look at. Reach out to myself or any of one of our staff, our planning staff, and we can look at it and see if it makes sense to add it to the list. What we don't want to do is have a bunch of like one-offs to say, well, this one parcel, this one time didn't like it. So let's make it a universal change for the entire city. You know, that's when you create a bad zoning code. And that's when your zoning code becomes so difficult to interpret that it doesn't make sense. But we also want to be consistent in saying we want to protect those neighbors and we want to protect those existing community characters. So how do we do that? But again, big picture wise, if you see things that just don't make sense, bring it to my attention. We can add it to that list. And what we'll do is we will go back and update those changes, and that will go through a pretty public process as well. That has to go back to Planning Commission. So all those 210 edits will go back to Planning Commission for their review and comment and recommendation. And then it will go to City Council for their review and final approval. And then next, would it be possible to give NABs feedback when their advice makes a difference on Planning Commission decisions? I think that's a great comment, because I think a lot of times NAB members feel like they're not being heard. And you know, how do we do that? I don't know if it's a matter of feedback back to the NABs after it's been through Planning Commission. Sometimes I think it helps for you guys to see the staff reports that the final site plan that went to Planning Commission got approved by Planning Commission, and see some of those conditions of approval. We do have a list. If you want to get on the list, we have all of our development review memo. This is an email that gets sent out twice a month. It shows you every development application that's come in. So you can see the applications, you can see what's proposed. And then we also have a list of Planning Commission meetings. So if you want to get a copy of all the staff reports that are being shown and provided to our Planning Commission, you can also get on those email distribution lists. And you can see ultimately how the project was proposed to turn out, and then definitely follow up, you know, with a staff person, the case planner assigned, and ask, you know, how that final project turned out or what Planning Commission recommended approval or denial on. Let's see. There's still some open areas in town where people have cattle and horses. Are these protected in the code or open to development? Yes. I'm going to say blanket yes. Are they protected? Yes. Are they open to development? Yes. As long as they're there and they're existing today, generally, you know, we as a city are not going to ever shut them down. If they ever change hands and a new owner comes in, then they absolutely have the ability to request a change to the zoning and request some kind of development. So unless they are protected by some kind of, you know, conservation easement or something, some kind of open space, there's always the chance that somebody could come in and request that they be developed, and they go through that development process. So the city generally doesn't have any specific requirements to say that land is open space and will never be developed. We see a lot of areas that are zoned open space, and a developer will come in and ask for a zone change and then development. So, you know, there's no, unfortunately, guarantee that any land that's open space or has cattle today will be protected forever. All right, let me see if I missed any more. So we got the newsletter. Thank you, Nick, for sending that out. Again, that's our development review newsletter. You can keep up to date on what projects are approved citywide, or at least planned for review citywide. And that's big picture stuff. That's not building permits. And then it says, I would like to recommend that the interactive map on the Nabs pages be refreshed more often. Absolutely. We realized about 3 months ago that the map had not been updated at all. We have a glitch in our system and we're trying to figure out how to fix it. So we're working on that, and I apologize for that. There was a lag in Q4, quarter four, fourth quarter 2021 and first quarter 2021. We are, like I said, we're working on that. It's a IT issue, and I apologize for that. If you ever, for whatever reason, aren't getting applications through that development review memo, not able to link to review those applications, reach out to our staff, and we can get you set up with whatever the quirk is in the system.
I maybe answered the last question that was just put in because it is about the comment forms, which NAB members fill out. And maybe you can just add any additional comments about Angela about the comment forms if you'd like to. And then I just have one kind of last closing announcement about some future training things coming up, and we'll be done for the evening. So why don't you handle that last question before we finish up?
Okay, great. So definitely the NAB comment forms, we highly recommend that you as NAB members and the general public as well, if you have something on a project that you want to provide comments on, definitely provide those comments in that form. That is the way that we can track what your comments are. And keep in mind too, we get a lot of people that say, I don't like that development, don't build it. There's only certain things, because our zoning regulations, that we as staff have the ability to recommend approval or denial or make changes on. So if it's a development that is allowed per our zoning code, we as staff can't just deny it. What we try to do is, again, mitigate those impacts to the best of our ability. And we try to hear what the neighbors' concerns are. Is it height? Is it, all the additional traffic? Is it not enough landscaping? We try and find that balance, because we have a zoning code that tells us what development can happen and how it can happen. We try and balance that with what the neighbors' concerns are. And I will say it's very rarely that we get a happy, median where the developer walks away happy and the neighbors walk away happy, but we do the best we can to really provide better projects and build, a better city. We all live here too. We want to see the city grow. We want infill to happen. We want you to be able to live and work and walk and recreate all within the same area. But it's challenging to do, especially in a built environment where we don't have great public transportation and we don't have, a great system of sidewalks that are already there. So there's a lot to do, and it's very expensive. And again, as a city and as a planning and engineering and building department, we hope that we work with the public the best we can, and also understand the rules and the regulations that we have to follow, and that the development community is also tasked with following.
Amazing, thank you. And yeah, so just to reiterate what Angela was just sharing, that on those NAB comment forms, if there are things that you can actually specify that are, if you are a neighbor in that area and traffic stacks up at this left turn lane, if we had, headlights would show through this area, be specific about your comments so that those can be helpful, rather than just being blanket statements of, I don't like this, or this isn't good for the neighborhood. Any specifics you can add are helpful. Well, thank you everyone for joining us this evening. And thank you, John and Angela, for your time sharing a lot of this with our NAB members. I hope this was informative for everyone. If questions come to mind over the next couple days or so, please do utilize the nabs at reno.gov email and nabs@reno.gov. And we'll try and get back to you about any additional questions. And then also just want to let you know that our clerk's office is creating a video training on public records requests and stuff like that, which will be helpful to you if you have any questions about that. And our communications team is also developing a video that will just educate NAB members and other board and commission members on how to communicate maybe with the public about things, what's an appropriate use of your voice as a NAB member, and how to just make sure that you are understand just the role that you have as a representative on a board, on a city board. So Thank you so much for your time, and thank you for serving on a NAB. It is a service to your community, and we really appreciate it. And I hope you all have a wonderful evening. Thank you.